Get ready for the dictation. Start. Heard learned counsel for the petitioner and learned counsel for the respondents. Perused the impugned order dated 28/10/2015 passed by the subordinate judge 2nd Munger entitled suit number 14 of 1999, whereby the learned court below allowed the amendment application filed by the plaintiff's respondents. At the time of hearing of this writ application, the learned counsel submitted that he is challenging only one part of the amendment detailed in clause 10th of the proposed amendment, by which a new paragraph, that is paragraph 10A, is sought to be added in the plaint. The learned counsel further submitted that the suit was filed by the father of the plaintiffs, namely Ratneswar Prasad Singh alias Ratan Kumar, only against defendant, challenging the sale deed executed by him in favor of the defendant. He died. After his death, the present respondents have been substituted as plaintiffs in the suit. The present plaintiffs, by filing amendment application, prayed for amendment for adding paragraph 10A to the effect that Ratneswar Prasad Singh had no right, title to transfer any part of undivided residential house by sale deed dated 1/11/1996, and the defendants have not acquired any right, title, even possession by alleged purchase, and they have no right to joint possession with the plaintiff over the alleged purchased land. According to the learned counsel, this amendment sought for cannot be permitted in view of the provision as contained in Order 22, Rule 4(2) of the Code of Civil Procedure. In support of his contention, he relied upon the decision of the Supreme Court 1986 for Supreme Court Cases 155. On the other hand, the learned counsel for the respondents submitted that this part of the amendment only relates to the legal position. According to the learned counsel, by amendment the plaintiffs only sought to bring to the notice of the court about the law. The learned counsel further submitted that still evidence of the petitioner, that is the defendants in the court below, has not started. Therefore, there is no question of prejudice to the defendant petitioner arises. The learned counsel further submitted that the amendment can be allowed if amendment sought for will be for the purpose of shortening litigation, and if it is not allowed, then there will be multiplicity of proceeding. It is admitted fact that the father of the plaintiff's respondent numbers 1, 3 and 4 and husband of respondent number 2 was the sole plaintiff in the suit. He died, and then these plaintiffs have been substituted in place of the sole plaintiff. Order 22, Rule 4(2) of the Code of Civil Procedure provides that any person so made a party may make any defense appropriate to his character as legal representative of the deceased defendant. In view of this provision, the legal representative has the right to make the defense which is appropriate to his character as legal representative. He cannot set up an independent defense of his own. The Honorable Supreme Court in the case of Balkishan versus Om Prakash and another 1986 4 Supreme Court Cases 155 has held that a person added in place of defendant and not in his personal capacity cannot raise plea which was personal to the deceased. In the present case, admittedly the amendment sought for is the independent right which the plaintiff's respondents are making by way of amendment. in view of the provision which is applicable in cases of the legal representatives of the defendant, in cases of legal representatives of the plaintiff, same analogy will apply. The dispute which is being raised by the substituted plaintiffs is against their father. This dispute will be the dispute between father and substituted legal representatives. So far, submission of learned counsel for the respondents that this is a question of law is concerned, it may be mentioned here that the question of law is not required to be pleaded. The question of fact is only required to be pleaded. If the argument of learned counsel is accepted, then even if amendment is refused, then also it will not cause any prejudice to the plaintiff's respondents. The law can be applied in the facts and circumstances of each case. So far, the submission of learned counsel for the respondents that no prejudice will be caused to the petitioner is concerned. In my opinion, on this ground, regarding no prejudice, what has been prohibited under law cannot be permitted to be allowed by way of amendment. Stop.